Good evening. I'm gonna be a bit German about this, Jay, no? Doctor,
Mhm.
Professor, Attorney, Jay Batumbakal, di ba? Ganyan sa mga German conferences. All your titles should be there. Even si Merkel, di ba? Si Chancellor, Doctor, Angela Merkel. No? So I'm gonna go German about this. Thank you so much, Jay Batumbakal, for joining us, Professor.
Thank you, Chad, and to all our viewers or listeners. Good day.
Good day and hopefully good times, no? Obviously marami tayong pag-usapan dito sa West Philippine Sea issue. And obviously, Jay, yung mga ginagawa natin over the past 6, 7 years, hindi naman walang ambag or walang saysay, pero parang kulang, no? Since we still keep on hearing yung etong regurgitated disinformation, very pro-China, obviously, by no less than people dito, no? I don't know kung may makikita kang ganyan sa Malaysia or Vietnam na biglang openly pro-China yung sinasabi and getting away with it. But
Uh,
the Philippines is the Philippines and well, democracy daw tayo. Pero pag-usapan natin yung disinformation shortly by going to the facts about the West Philippine Sea. But Jay, just before we go to the meat of the discussion, can you tell us bakit naging academic ka and why did you specialize in maritime international law but hindi ka naging ano, I don't know, criminal lawyer, corporate lawyer, you know, the usual career path for people that went through the law school?
well, honestly speaking, I was looking for a niche.
Right.
I did try litigation. I did try to go the usual route, but in the end, I decided that it wasn't for me.
Mm,
So I was looking for something that was stimulating and something that few or no other lawyers had gone into.
right.
And at the time, this was early 1990s. No, the law of the sea was relatively new.
Yeah.
It was about to come into force, and we are an archipelagic country. So my professor at the time, in fact, he's now the Secretary of Energy,
Mm,
Professor Lotilia, encouraged me to go into maritime studies. So during my graduating year, my research was on coastal zone management.
right.
And then after a few years, when I had the opportunity to take masters, I focused on the law of the sea.
Mm-hmm. And
And since that time, I've been doing research and advocacy on it ever since.
Dr. Batumbakal, why law of the sea and why go all the way for a PhD in law of the sea? Sa Canada ka nag-PhD, di ba? Why there? I mean,
Yes.
like, can you explain us a little bit? Yeah.
Well, when it started, 1990s, 95, no, I was involved in a project which partly was meant to prepare the Philippines for implementation of the Law of the Sea Convention. Okay. It entered into force in 1994, as you know.
Right.
So the Philippines at the time, after having negotiated or participated in the negotiations of the Law of the Sea Convention, saw that there were challenges in its implementation. So they were looking for people who would
Right.
want to study the matter.
Right. Right.
And I just happened to be the one that they were able to recruit, no?
Right.
So si Professor Lutilia together with Heidi Yorak were able to endorse me to a university in Canada which specialized in ocean studies,
Right.
and that's Dalhousie University. So I took my master's there,
Right.
mostly focused on coastal and marine management. Okay, and then when I came back, immediately I was put to task with various policy studies, supporting the government, particularly the Department of Foreign Affairs, in dealing with the implementation of the law of the sea, as well as so many maritime issues that came up. I also did a bit of private consulting work
Right.
since I had the background. I also did a lot of work on coastal resource management. These were development projects. So I was able to do a lot of consulting work on fisheries, even shipping at some point. No? And it kept on like that until around 2003. I decided, okay, it's time to take a PhD. And I went back to my alma mater in Canada to pursue a PhD. So I got even more knowledge about various other issues that I did not tackle before, such as energy, ocean energy
Right.
issues, and natural resource, broader natural resource management issues in the marine field. Yeah. So yun nga, ever since, bale, since 1997 when I came back, I've been doing just ocean-related research. No? Everything it has to do with ocean law. That's why it's been a very, very interesting career.
Right.
Covered so many different topics, everything from coastal fishery management all the way up to international maritime boundary negotiations and high seas fishing and everything in between. And up to now, there are still new topics, new subjects of study coming up.
Of course, yeah. Dr. Badang Bakal, how did you get involved with the Benham Rise Philippine Sea issue? Because you played a very important role. I think that's the closest you came to being really, working with the government through and through to make sure the Philippines has its best possible, legal claims in such a resource-rich area.
Well, actually, I was working with the government on and off for
Mm.
many years, even before that. And it was because of that when
Right.
the decision was finally made to pursue a claim to an extended continental shelf in Vietnamese region,
Right.
they got in touch with me. I was already doing my PhD studies in Canada.
Right.
But it so happened that I also knew one of the commissioners of the Commission on the Limits of the Continental Shelf, no? Because he also studied there and we had become colleagues. We had worked on a project together. So Namria got in touch with me and sought my participation. I remember the first meeting we had was even by Skype, no? And it was rather primitive. Yung mahirap magkadinigan pa mga at that time. But I managed to attend the first meeting, yeah. And then from that, introduced them to the commissioner who then was able to help us prepare this. No?
Dr. Badambakal, my sense is you were not just finding a niche, you were trying to fill up some sort of a vacuum because I remember whenever you talk about UNCLOS, international law, the names that pop up from a region are like people like Ambassador Jalal or Tommy Ko, for instance, right? A couple of people from Indonesia, from Singapore, and some of them are, of course, still among us, and the way they're treated as the kind of like godfathers of, UNCLOS as far as ASEAN is concerned. But we know that in the case of the Philippines, panon pa ni Marcos, and I think Estelito Mendoza played quite a role also during this time, no? We were very central also to making sure na yung mga bansa with similar interests, mga smaller countries, we have a kind of an international regime that ensures we have rule of law rather than rule of jungle. Can you tell us a little bit about that? Yeah.
Well, early on, no, the Philippines decided to pursue, to advocate a particular new concept, no, the archipelagic state concept and the archipelagic waters, because under the state of international law at that time, states were only entitled to a small strip of water, basically 3 nautical miles from shore. That's your territorial sea. Everything else beyond that is the commons already. Other states can use them for whatever purpose and whatever activity they wanted, including fishing. And that meant that in the Philippines, our inter-island waters, no, many of which are more than 6 nautical miles apart, no, they would be high seas, no? So the Sulu Sea, the Bohol Sea.
Medyo sabog ang mangyari dyan, di ba?
Yeah, it would be a fragmented set of islands, essentially.
Yeah.
And the Philippine government early on, 1950s, already realized that this would be not in its interest, and that's why it introduced the so-called archipelagic doctrine or the archipelagic concept. No? We made that bid in a note verbal to the UN Secretary General when he consulted the member nations of the UN, no? On what should be the width of the territorial sea. Okay, and our answer was basically that we are a special case. We are an we're an archipelago, and we have archipelagic waters or inter-island waters, and these should be considered as part and parcel of our nation.
Right.
So we did not distinguish between land and water, essentially. And the idea was to unify all these scattered islands of the Philippine Islands. No, we were called Philippine Islands for a very long time. So that was the seed of this advocacy. Indonesia joined us because they were in a similar situation, even though they were larger.
Right.
And together we led a group of states called the Archipelagic States Group, or the Archipelago States Group, actually. during the UN Convention on the Law of the Sea negotiations. So we wanted to, number one, get the international community to recognize our sovereignty over our inter-island waters. Number two, recognize that we were one unit, basically, what became the archipelagic state. No? So also to recognize that we're not just scattered islands, but an archipelago. And we also wanted to have control over the passage of foreign vessels through our inter-island waters. Okay, so those are the three basic points. No? But as time went on, of course, we are a small group of states, all developing states at the time, against an array of nations, no? In multilateral negotiations. So there's a give and take process, there's a compromise process. So in the end, we got some of what we wanted, but not everything. Okay, so I think particularly the achievement that we did reach, however, no, is some of the most important ones. Number one is the recognition of our sovereignty over our inter-island waters, no? What is now recognized as archipelagic waters, and the archipelagic state concept, the recognition that we are one unit. No? That was very, very important for us politically, especially during that time. Okay? We didn't get everything that we wanted with respect to the degree of control over foreign shipping passing through our inter-island waters. No, but at least we were able to get most of it.
This is the 70s, Dr. Batumbakal. What are we looking at, 70s?
Oh, well, if you go back to the original advocacy of the archipelagic state concept that started 1955, 1956.
Right.
And it kept being rejected by the international community. There weren't enough votes in its favor. All the way up to the 70s. No?
I mean the culmination of that negotiations and all of that. 70s.
The negotiations
so Marcos era.
culminated in 1982. No? After almost 10 years of negotiations.
10 years, yeah.
Yeah.
And Estelito Mendoza, among others, played a very important role, my understanding is, right?
Yes. Yeah, Arturo Tolentino, Estelito Mendoza.
Right.
I forget the name of the head of the NAMRIA at the time.
Right.
Well, what became the NAMRIA rather at the time they were known as the Bureau of Coast and Geodetic Survey. They basically pushed these ideas for 10 years, and there's a whole record of Philippine interventions along these lines.
Right.
And so, in the end, it culminated in what is now known as Part 4 of UNCLOS. It's an entire part. It's sui generis. It's new to international law. It's a treaty-based set of rules. Okay, and because of that, we are now able to claim not only sovereignty over the inter-island waters of the Philippines, but also the EEZ and continental shelf, no? Which greatly expanded our resource base. Before UNCLOS, we were making claims, we were making a unilateral claim to the so-called Treaty of Paris limits.
Which is weird, like kind of a square shape, very parang,
it's an arbitrary box from the islands.
Yeah.
And that claim was consistently rejected by the international community. Nobody recognized that. In exchange for that, however, we were able to get the 200-mile EEZ and continental shelves measured from the archipelagic baselines, which is much bigger in area. And so we were able to actually expand our resource base in the oceans because of UNCLOS. No? So that's another contribution, I think, that we were able to make. Without that, that push, we probably would not have as much in terms of additional resource areas. No?
Right. Dr. Batumbakal, I just want to understand, I mean, for the purpose of our audience also, how we went from that negotiation to the early 1990s where we finalized and ratified UNCLOS, and then the baselines law that comes in the late 2000s. So what are we gaining through this milestones? Just to para lang mag-gets ng tao na hindi lang nakatunga nga yung gobyerno natin all this day. Kasi in fairness, we have been doing something on this front.
Well, quite a bit, no? Number one, before UNCLOS or without UNCLOS, the Philippines continental shelf, for example, would be limited to only the 200-meter isobath, meaning a depth of 200 meters,
Yung pababa. Yeah, deep
or the
depth.
depth
Yeah, yeah.
of exploitability, which is a technological criteria. Okay?
Right, right, right.
It wasn't clear at all, and it depended on the available technology. And when you look at the Philippine charts, there are places in around the Philippines where practically there's no continental shelf. So like east of Luzon, kantilado yung seabed doon because there's a trench. Um, well, even the west of Luzon is also similar, no, in that, and also east of Mindanao, no, it goes straight into the Mindanao Trench. So our continental shelf would be very, very narrow. Okay?
Yeah.
But with UNCLOS, no, regardless of the shape of the seabed, we're entitled to 200 nautical miles all around, no, measured from our baselines. So that's a huge increase
Yeah.
in the potential mineral and petroleum resource areas that we can access. Okay? In terms of the archipelagic waters, the sovereignty over the archipelagic waters, like you mentioned, no, before we were only, well, the international community would only recognize 3 nautical mile limits. Even if we were to claim 12 nautical miles, no, essentially the Sulu Sea would be the high seas open to all states for any
Yeah,
purpose,
interesting.
including exploitation.
Yeah.
No? So now with UNCLOS and the archipelagic state concept, we were able to enclose the Sulu Sea, no, as well as large areas of our other inter-island waters. No? So these are the gains that we made as a result of that.
Thank you for that. So the baseline's law that came also late in 2000s,
Yes.
it kind of fortified what we were already gaining under UNCLOS. That's what you're saying. Pero may kulang pa rin
Yeah.
ba? Legally speaking, what do you think are kulang pa rin pa in terms of
Well, of course, may kulang pa kasi the baselines law is basically just the starting point. There are still, kumbaga, persistent doubts or problems arising from the fact that a lot of people are still confused as to the nature of international law and UNCLOS and how it relates to our unilateral domestic claims, okay?
right?
Particularly the Treaty of Paris lines. Okay? These unilateral claims simply are not recognized by the international community, and therefore they're not binding on them. Okay, and the only ones that they will recognize are those based on UNCLOS. So we had to enact RA 9522 in order to establish first the foundation, which is the baselines, the archipelagic baselines in the Philippines. We had baselines before, as early as 1961, but they were not in conformity with Part 4 of UNCLOS, no, the result of years of negotiation. So 9522 basically aligns our baselines in accordance with the standards under UNCLOS. And therefore, other countries can now, even on their own, measure the maritime zones based on those archipelagic baselines, and they will have an idea of what maritime zones of the Philippines they are in whenever they're passing through our archipelago.
Which I think brings us really to the meat of discussion today, because speaking of confusion, or some would say, manufactured confusion about international law, about UNCLOS and its relevance for the Philippines, let's go to the Philippine arbitration case. The first thing we hear, and we know where this is coming from, not only from Beijing, but from their many friends not too far away from us. One of the arguments they always make is that, well, hindi naman sumali ang China. So if China did not participate and China doesn't recognize, if China believes this is a piece of trash paper, which Duterte also reiterated in his own variation, then walang saysayan. Hindi naman nag-attend ng China. So ano yan, kanya-kanyang di ba, lutong Macau in that sense, paradoxically. Can you explain to our audience, Jay, in what sense was that arbitration case binding or final?
Yeah, well, number one, all states, when they sign and ratify a treaty, they bind themselves to it. They commit to
Right.
abiding by the treaty, no? Otherwise, what's the point of entering into these agreements? Hindi ka lang pala susunod,
Right.
di ba? Now, both the Philippines and China signed and ratified UNCLOS, and therefore they bound themselves to all of its provisions, no?
Right.
Hindi pwedeng unlike in other treaties, in UNCLOS hindi pwedeng magkaroon ng tinatawag na reservation, meaning
Yeah.
some parts you will not
So sa
accept
parang
and it will be
ICJ,
binding.
right?
Okay?
Right.
So, so in UNCLOS, it's a package deal. It's either all or nothing. Okay. So if you signed and ratified, then you commit to all of its provisions. Part of those provisions, Part 15 particularly, commits all of the states, all of that signed and ratified, to submit themselves to the dispute settlement mechanisms. Included in those dispute settlement mechanisms is the arbitration mechanism. Okay? Arbitration is, it's like a court, except that you basically create a panel, no,
Right.
to rule on an issue that you bring before the panel for a resolution. Okay? And China is bound by that provision as well. Okay? There are, of course, various exceptions. No, the way the Part 15 dispute resolution mechanisms are structured, it's very complicated. No? So there are what we call exceptions and exclusions and exemptions.
Yeah, I mean,
No?
sorry, Jade, I
But
mean, Article 298, Section 2, diba? I mean, there's already, China tries to invoke that as an exemption. Can you explain to
yeah,
us why that's not, definitive in its sense? Just because you invoke it doesn't mean it's automatically valid, right?
yeah, it's
Sorry,
not
preemptive lang
because
ako because I
even
know what the
if
other side is gonna say. But there's that Article
even if there
298, yeah.
are exceptions, no, to and exemptions to jurisdiction and to these dispute settlement mechanisms there, no, you have to make sure that those exceptions apply.
Right.
And the thing is, when the arbitral tribunal basically looked at all the positions and statements made by the parties,
Right.
for in China's case, all the positions and statements it's made out of court, no, which is still binding on it because after all they're saying those things publicly.
Right.
No? They found that none of the exceptions applied. Okay, so they were still bound to go through the arbitration process, no? Because none of their objections, none of their exceptions to jurisdiction were applicable, no? Given the case that we had put before the court.
Right.
And the case that we had put before the tribunal was simply this, no? Certain questions of fact about the features in the South China Sea, no? Such as whether they are high tide elevations or low
Right.
tide elevations, whether they generate territorial seas or not, whether they generate EEZ or continental shelf zones or not. Okay, and also questions of law. Are the actions taken by China against the Philippines up until that time, no, this was around between 2010 to 2013, were they legal, no? Or did they contravene international law? Okay. Now, that second question depends on the resolution of the first few questions. Okay. And that's why it became important for the tribunal to make its findings of facts, looking at whatever information is available, both those that were submitted by the Philippines and information that the tribunal itself had to go out of its way to find.
Right.
And in the end, no, it ruled in our favor. It basically ruled that a lot of features, there are features that are high tide elevation, such as the islands, the Pag-asa Island, Ito Aba Island. And there are features that are low tide elevation, such as Reed Bank, Ayungin Shoal, Mischief Reef. No? And then the tribunal ruled that the high tide features are the only ones that are entitled to a territorial sea.
Right.
Okay? But because of their characteristics, they are not entitled to EEZ or continental shelf zones. Okay, it's only territorial sea.
At
And
mahalaga yan, Jay,
territorial
because right, if this island suppose it can generate 200 miles, abot na sa Pilipinas yan, di ba?
Yeah.
So
Yan
malaking
yung-
stake natin to determine which is a self-sustaining real island or not, yeah.
Yeah, that is what China was banking on.
Yeah.
If it's able to show, or at least get the
Yeah.
tribunal to see that the islands may be entitled to easy continental shelf on their own, then their nine dash line claim might be based on an easier continental shelf claim, which would reach all the way up to just outside of Palawan and Luzon. No? And the thing is, the tribunal did not rule in that manner. It ruled that it's only entitled to 12 nautical mile territorial seas, no easier continental shelf. And because
Right.
of that, the area of legitimate dispute between the Philippines and China was reduced immensely. It's only now these small pockets of islands and rocks, no, with
Right.
their territorial seas. But outside of those pockets, it's either the Philippine easier continental shelf that you're looking at because it's within 200 miles of Palawan,
Right.
or the high seas, which is common to all states. And that's why for us, it was a win. It was it was very important because once the tribunal ruled that the area in dispute is actually these small pockets,
Yeah.
and it found that the Philippines still had its 200-mile EEZ and continental shelf zones, the Chinese activities against the Philippines in the Philippine EEZ and continental shelf zones could now be assessed legally. Okay?
Right.
And they found that these were mostly in contravention or contrary to the Philippines' rights and entitlements. Okay? So that's why most of China's actions were deemed to be contrary to international law. They were illegal.
Right.
It's only a small portion of the Philippine claims, the ones that we are complaining about, which the tribunal could not rule on, no? Because it was now either inside those 12 nautical mile territorial seas and therefore still legitimately disputed, or it fell under what is known as the military exception to UNCLOS, the military activities exception to UNCLOS. These are not covered kasi by
Right.
the rules of UNCLOS.
Uh, Thank you, Jay. Because next I want to go into this issue of compulsory arbitration. I think we have to explain to people what is the basis for that. But can you quickly just explain to us also the binding nature of this case? Because in works we have cited Article 296 and Article 11 of Annex 7, which makes it final and binding. So just because China did not attend doesn't mean that it doesn't apply to them. It doesn't work that way, diba? And then
No.
as you were explaining, it is not up to China to just unilaterally say the exception applies. It is up to the arbitration body itself to determine whether the invocation of that exception has a basis or not. So, because I think a lot of people, lay people, or people who do not understand the nuances, think that just because there's an exception clause, just by invoking it, automatically it applies. But no, the court made it clear it's up to us to determine whether may basihan yung invocation of exception mo. So, hindi
Yeah,
pwedeng
only
ganun.
the tribunal is competent to
To
determine
determine, not
the
China
extent of
unilaterally. So
Oh,
what is
not
the
the
Article
party.
296 and Article 11 of Annex 7? In what sense does it affirm the finality and binding nature of that?
Well, as we said, no, China's signed and ratified UNCLOS, and all states are bound by an even more fundamental principle in the international law.
Yeah.
That's the principle of pacta sunt servanda.
Right.
States must comply in good faith with the agreements, the treaties that they signed on to.
Good faith.
And therefore, China is bound by that particular provision, especially
Right.
that it is final and binding upon them. Okay? Now, the other thing that's very important about this is that when you look at the tribunal's judgment, okay, it is basically mostly about findings of fact. These are objective facts. It's whether a feature is above water or
Right.
below water at high tide, or whether it has the capacity to sustain human habitation on its own. No? These are objective facts. And no amount of argumentation now can change that. Okay? Second, it also made findings of law,
Right.
no? Meaning the application of UNCLOS to certain activities that China undertook against the Philippines. Okay? And the tribunal ruled that based on the facts and circumstances
Right.
and the available rules of the law, China contravened the Philippines' rights and obligations. No? And in fact, also, China acted contrary to international law as well, in general. No? And we're talking
Right.
about the obligation of all states to conserve and protect the marine environment, for example. That's not owed only to the Philippines, it's also owed to the rest of the world. No? And
Right.
China acted contrary to that, no? By building these artificial islands, destroying huge areas of coral reef, no? Without notification and without justification. So yun, that's why they're
Yeah.
really bound by it. No, it's not for the party to say whether or not they're bound. I mean, like an ordinary person, if you're brought before a court, you
Right.
cannot tell the judge that you do not recognize their jurisdiction. Okay, you're not the one who can you can make that decision. No? So in the same thing here, China is not the one
Who
with the
determines?
authority to determine whether or
Yeah.
not the tribunal had jurisdiction, given the facts that it had already signed and ratified the convention, it was bound by these provisions on dispute settlement, no? And the case went through the process.
Yeah.
Its non-participation does not bar the validity of the proceedings. No? Otherwise,
Right.
again, like in an ordinary court case, di wag ka lang appear sa judge, ibig sabihin invalid na yung decision. Hindi pwede yun. No? So a similar thing is happening here. Just because China did not participate does not mean that the judgment is invalid. No? In fact, it could be argued that their non-participation formally in the proceedings, no, was a kind of waiver as well. They took their chances valid in the case when they refused to argue and present evidence and send counsel to influence or somehow give inputs to the judges and their decision making.
Right.
Well, by the way, it's also not the case naman that they did not participate completely because China was not silent all this time.
That's my point. We keep on talking about the exemption clauses. Who's mentioning it? Obviously, China, right? So there were indirect participation or liminal participation.
Yes, yes. So even while the proceedings were ongoing, they kept issuing public statements,
Right.
official position paper, etc., etc. So they were actually, in a way, they were cheating because they were putting out their arguments, even some of their evidence. They were pointing to some of their evidence, while not actually appearing before the tribunal, di ba?
Right.
So it's unfair to the other party, which is bearing all of the expenses and doing all of the effort to have a proper proceeding.
Right, Jay, which brings us to the number 2 issue because China was not only trying to have it both ways, right? On one hand, saying, oh, we're not participating. On the other hand, trying to influence the process by making these comments. But these comments were not neutral comments, right? Or these comments were not just about China's claim. These comments were also meant to, at least some of the comments by China were meant to besmirch the body and question its validity and jurisdiction. So let's go to the number 2 issue. So the first issue we resolve is that you cannot unilaterally just say, I'm exempted. It doesn't work that way. It's an issue that has to be adjudicated by the proper body. Which brings us to the second issue, which is, was this a proper body? Was this a body under UNCLOS and therefore binding? So let's talk about that. So this brings us to Article 287, Annex 7, compulsory arbitration. Can you, Jay, explain to our audience bakit itong, by the way, it's not PCA, right? People keep on saying PCA. Explain where is this mistake with PCA coming from and what's this court in The Hague all about?
Well, the tribunal is a tribunal that is established under UNCLOS. Its power and jurisdiction flows from UNCLOS. Okay?
Right.
The PCA, or the Permanent Court of Arbitration, simply serves as the registrar, meaning what it did was it provided the administrative support
Right.
and the facilities for the tribunal to be able to meet and hold the proceedings. Huh?
Parang secretariat.
Parang secretariat.
Yeah.
It's lodged in the PCA for records purposes, basically.
Right.
No? Para nga madali na malaman kung nasan ba napupunta yung dokumento, where they should be sent, who will keep the original copies, where will they be archived, etc.
So, Jay, paki-explain yung compulsory arbitration Annex 7287 because people keep on saying that this is not even PC as you say. So wala siyang jurisdiction, wala siyang validity. Can you explain to us the compulsory arbitration mechanism under
Yeah.
UNCLOS? Yeah.
The compulsory arbitration mechanism is provided for by UNCLOS itself.
Right.
Okay? It exists independently, okay? And its power and authority arises because the parties gave them that power and authority. When they signed and ratified UNCLOS, they basically established this mechanism for arbitration
Right.
and provided the basic rules of procedure for it in Annex 7. Okay? Because of that, a tribunal that is constituted in accordance with the procedure
Right.
under Annex 7 when it is invoked is a valid and authoritative tribunal.
Right.
Okay. Now, the fact that it exists separately from the PCA or that
Right.
exists separately from ICJ or is not even part of the UN, meaning these are not UN employees,
Right.
that is all irrelevant.
Mm-hmm.
Okay? Because the power and authority of the tribunal comes from UNCLOS itself,
Right.
the convention itself, not anything else. And the power and authority given to UNCLOS flows from the state parties that signed and ratified it. And that includes China and the Philippines.
Right.
Yeah.
Yeah, again, I think it would be nice if we post it. So it's very clear, John's United Nations Article 287, no? When signing, ratifying, or according to this convention or at any time thereafter, a state shall be free to choose by means of a written declaration one or more of the following means for the settlement of disputes concerning the interpretation or application of the convention. A, the International Tribunal for the Law of the Sea, the International Court of Justice, and arbitral tribunal constituted in accordance with Annex 7, which is what we did. And then D option is a special arbitral tribunal constituted in accordance with Annex 7 for one or two of the categories. So this is very clear. Andun yun sa Article 287 where countries have a choice which
Yes.
option to go forward to.
And that choice from these four different procedures, the four different fora, has to be made at the time that they signed and ratified UNCLOS.
Right.
And if they do not make a choice when they do so, when they sign and ratify,
Right.
wala silang sinabi which of the four they want,
Right.
they are automatically deemed to have selected arbitration.
Right.
And that's where the Philippines and China had something in common. We both did not make a choice, and therefore we are
Right.
both deemed to have now permitted arbitration to be the mode of dispute settlement between us in case we have an issue over the interpretation application of UNCLOS.
Right. So we have settled so far a number, just to recap. So first we explained why China's invocation of exemption clauses cannot be unilaterally invoked. It is something to be adjudicated by the proper body. And that even China's claim of non-participation is questionable given how it was raising comments. Which brings us to the second issue, which is China actually trying to question the validity or to besmirch the validity of the court. And this is where we explain that actually there is a compulsory arbitration part of a number of options provided to us under Article 287 Annex 7, and we chose one of them. No? Now, this brings me to issue number 3 because a while ago, Jay, you mentioned, well, hindi naman pwede yung kunyari, kinasuhan ka ng kapitbahay mo, tapos sabihin mo, ay, hindi ko ma-recognize, ayoko yung judge niyan, hindi ako pupunta dyan. But nevertheless, Jay, of course, we're talking about international law. So we're talking about law that deals with individually sovereign states. So clearly, unlike yung court, hindi siya pwede magpadala ng, I don't know, barangay tanod or police. So there's no enforcement mechanism. I think all of us had no illusions about that. But nevertheless, ano yung ambag nung arbitration award na yan, even if China has rejected not only the procedures, but definitely also the outcome? Obviously, a number of things comes to our mind. First of all, I don't hear China using the 9-dash line anymore, right? Since the arbitration came out. Maybe there's a reason why, right? We also see that some of our like-minded neighbors have been invoking the Philippine Arbitration Award to reinforce their own claims, whether it's Vietnam, whether it's Indonesia, which is not even a claimant in South China Sea, but they're worried about what's happening North Natuna Sea, Malaysia in 2019 when they pushed for another extended continental shelf claim, they somehow also were mentioning the Philippines. So may ambag yung ginagawa natin not only for us but for neighboring countries. But lastly, and I think this is very important, is we provided also a partial legal pretext if not full-fledged pretext, not only for the US, but a number of international powers to say yung China's claims have no basis, therefore they cannot just go and make fake islands and then kick everyone out of the area. It doesn't work that way, and hence we have more freedom of navigation operations. So my understanding, Jay, is that hindi totoo na wala ambag yan. Nevertheless, having said that, what are the options forward? Can the Philippines go for supplementary or additional corollary litigation in order to make China pay for its clear non-compliance as an outlaw in the South China Sea? One of our good friends, of course, Associate Justice Carpio, mentioned about pushing for court cases to seize assets of Chinese companies who have been involved in illegal activities in the area, let's say Sinopec, CNPC. We also had this case by the late Foreign Secretary and the former Associate Justice Carpio, the other one, right? Where they tried to take the case even to ICC, right? So they try to bring elements of human rights and UNCLOS together. So there are some ideas and some moves to make sure na China cannot just get away, in short, to make sure walang impunity dito. What is your take on this, Jay?
Well, again, no, yung South China Sea arbitration, malaki yung ambag actually. Napakalaki.
Yes.
Why? Because before the arbitration, there was really a lot of legal uncertainty. It was not sure
Right.
among the various states whether or not China did have a proper and legitimate claim to that area that they had enclosed in the 9-dash line.
Right.
Well, it didn't help that China did not clarify what exactly it was that they were claiming. Okay, but there was no certainty if it would be brought before a tribunal. Would the tribunal recognize that it is possible for China to basically claim and dispute everyone else's claim to the various parts of the South China Sea? Okay. Now that we have the arbitration decision, it is very clear that China does not have such a vast and excessive claim to the South China Sea. No, its constant invocation of historic rights, even historic facto, these were all ruled upon by the tribunal as simply not acceptable. No? If at all, whatever claim that they did make to this vast area of the 9-dash line, they only started making it and actively pursuing it in 2009.
Right.
Before that, malabo. You do not even know what it is that they're asking for. So how can you even how can you even respond properly? Okay. In the meantime, the surrounding Southeast Asian nations, the smaller Southeast Asian states, have been aligning their claims with UNCLOS. They've been claiming only their 200-mile EEZs from their mainland coasts and treating these islands in between as isolated enclaves of 12 nautical mile territorial seas. No?
Right.
Pare-pareho yung position ng Philippines, Vietnam, Malaysia dito. Okay?
Right.
And because of that, each one of the Southeast Asian nations now has a share recognized by international law. They now have a share of the South China Sea. It's their EEZ and continental shelf and all of the vast resources within their respective portions. And there is also a common area in the middle, no, which is open to all states, no, not just us, but within the region, but also outside of the region. And that, I think, is a much more equitable distribution of the South China Sea than what China is claiming, that everything belongs to them.
85%, right? Yung 9-dash line, roughly, yeah.
Yeah, and because of that tribunal decision, no, it is now being cited and invoked, as you said, by the other Southeast Asian states, even though they were not parties to it.
Right.
They are invoking the reasoning within it, and it is a very powerful reasoning. It's very powerful argument that they can use even against China in their respective bilateral dealings with China.
Right.
And
So even if they're not the parties, sorry again, because we see a lot of disinformation around it. So yung sinasabi, anong marites ng Vietnam, di naman sila kasama sa arbitration case na yan. Bakit nila in-invoke yan? So can you explain that? Yeah.
Well, kasi nga, actually Vietnam helped the Philippines in the arbitration case by submitting a letter which expressed its legal opinion or legal position about the claim to the EEZ, about the claim of China, and about the status of the islands. No? And it was fully aligned with the Philippine arguments, with the Philippine position. Okay? And the tribunal actually summarizes this in one part of the arbitration. So,
Right.
kinampihan tayo ng Vietnam. And because of that, the tribunal somehow was also encouraged or supported in its reasoning. Okay?
Right.
So, why is it important for Vietnam? Number one, hindi na nila kiniklaim yung buong malaking portion ng South China Sea, which
Right.
they used to. Okay? It's no longer an ambiguous claim because it also wasn't clear what their basis was. They
Right.
were citing the French annexation, but the French annexation did not include the waters. Okay, but now what they've done is basically draw back, no, draw down their claim to what is allowed by international law. No? And it is still a large part of the South China Sea. They still have their 200-mile EEZ and continental shelf. Okay, and then the islands are just small enclaves now. And they've also basically given up a portion
Right.
of what used to be their expansive claim. They gave it up to the international community as well as the rest of the region. Okay, so you see that they are in a way compromising with us and the other
Right.
ASEAN states in a way, no,